Welcome to this video on the probate timeline. Here we'll break down what happens in the first weeks, months, and year, and possibly even longer, so you could better understand why it could take longer than 9 months to complete a probate. If you're just starting out, you want to make sure to watch my previous video which covers more about probate, the duties of each person, and how to file a petition for probate. Please check out the link below for that video. Now, let's get started. Keep in mind that the exact process may vary depending on where you live. As a realtor here in Los Angeles, California, I'm going to provide you a general overview on what happens during that probate process. All right, let's start with the first step, which someone's going to do is going to be file a petition to probate, and then the court will appoint a personal representative who will be overseeing the proceedings. The next thing will be to file in the newspapers of general circulation in the area of the deceased a copy of the notice of petition to administer the estate. From the day the court publication is filed, there will be a court hearing date, which usually around 5 to 6 weeks, where an attorney will go to court for you. On that court hearing date, the judge is going to grant or decline what you initially asked in the petition to probate. Now, I hope that was filled out properly, or else it could delay this whole thing. So now it's going to be around the 2-month mark from filing the petition to probate and having it accepted. You should get from the court 2 documents called the letters and the orders. In the letters and orders, it will lay out the personal representative, who that person is, and let them know what type of authority they have over the assets. It will be either full authority or limited authority, and it will make a very big difference on the rest of the process. So let's briefly go over what full authority is and what limited authority in their timelines. Let's start with full authority, which is the ideal route to go through, and a good attorney usually could get you to get full authority. In full authority, the personal representative can open a bank account with an estate ID number, where there can be the bank account to hold all the funds of the deceased. The personal representative can now sell the property of the deceased. The personal representative will be able to sign listing agreements with the real estate agent and give it to their attorney. The attorney will send out a notice of proposed action to all heirs, letting them know that the home is going to be sold. If there is no objection within 15 days, the home can be sold and closed with no issues. So technically, going this route, you could sell a home within a month. Now let's go over limited authority, because with limited authority, it's going to be very different the way you're able to sell a home than going through the traditional home sale. There will need to be someone called the probate referee appointed by the court, who will come up with the price of the home. At this point, I really hope you have a realtor who understands working with a probate referee, and here's why. The referee cannot go inside the home and has limited access to just the values he finds of homes that have recently been sold, and also by doing a drive-by of that property. So once this probate referee makes a value of that home, the home must be sold for at least 90% of that number he comes up with. Remember, most homes are not ready to be sold, especially if someone just passed away. So imagine what issues this can lead to. So please pick a realtor who knows how to work with a probate referee to make sure the assessed value is accurate to the condition of the home being sold. Furthermore, the way the buyer purchases the home in probate while it's under limited authority is very different from a traditional purchase. The buyer will need to put 10% down and must clear all contingencies from their contract. Then you'll be able to give that to your attorney, and it will set a court date. At that court date, anyone can overbid on the property. Whoever is a winner, the judge will sign an order with that, and you can have escrow close the deal. This process is usually going to take 6 to 9 months to complete a home sale. There are many other steps and conditions involved, and I can make another full video on full authority and limited authority. So you can expect a lower sold price when having limited authority over having a full authority sale. Please find a realtor like myself to help you in this process. I would love to help you, even if you're not in my area. I could find someone for you, either a probate attorney who knows what they're doing or a realtor. Okay, now let's go back to the second month mark, as there's other things I would like to talk about. At that second month mark, you'll need to give a notice to all creditors, like any governmental agencies, credit cards, and any other known creditors coming after the deceased, their property. This is something that the attorney can set up for you. At this time, creditors will need to file in order to get paid by the court. It is also possible to get these things rejected, so they only have 4 months to get their monies. Please speak to the attorney on how you can possibly avoid these payments. So, just briefly a recap. File a probate to petition. At the 2-month mark, we'll get the letters and orders. And at that 2-month mark, we can begin selling the home and giving and sending out any notices to all creditors. If it is full authority, the house can be sold, and it should only take about 6 to 7 months from the start. If it is limited authority, you should be able to get the home sold and everything within around 10-month mark. Now, it's time to file the final petition with the court. The final petition is basically going to tell a story about the process step by step and let the judge know how much is left in this case. It will let the judge know to pay the probate attorney. It's going to be a set rate that's appointed by the court. The personal representative will be entitled for the same amount that the attorney is getting. The court filing fees, any newspaper, the probate referee fees, possibly a bond cost, any other fees that are involved. Now, whatever is left gets divided amongst all the beneficiaries. There will be a court date with the attorney, and he will go there. Once all the beneficiaries are paid, the case can be closed. If you have full authority, this whole process can take about a year. With limited authority, that can be from a year to a year and a half. Well, that's it for the timeline in this probate. I hope you found it helpful, and next week I will be putting a video together on selling a home in probate. If you found this information useful, please consider subscribing and sharing it with anyone who needs support like this. Please feel free to reach out. Thanks. Bye.